Having me, everyone. My name is Mike DeMuro. I'm a resident of Middle Village. Been living here in the Maspeth, Middle Village, Glendale area. I lived in all three of those neighborhoods at one point or another in my life. My wife, who's here, is the same way, a resident here all our lives. So we're homeowners. I've owned the house I live in now for the last 21 years. And we're concerned, and we probably have a lot of experiences in common if you've lived in the area for a while, or if you're a homeowner with construction projects. And that's what I'm here to talk about. So first, I just want to get a few disclaimers out of the way. Just to be clear, I'm not an attorney. I'm not here to offer anybody legal advice. I'm not an architect, an engineer, or anybody who's an expert with the building code or with the zoning regulations, none of that. As I mentioned, I'm just a homeowner in Queens, like many of you, and I happen to have had the experience of doing 3 construction projects myself on my own property in the last 10 years. And in addition, I've had the experience of having neighbors doing construction projects as well. So that's what I'm here to talk about. It's that experience, okay, that I want to talk about. There are various issues that I want to address with you that I think everyone should be aware of as a homeowner. I'll be talking about a specific example, okay, that's taken from my experience. I have to apologize to say I'm not going to talk a lot about the personal details of it, and most of the reason for that is that this issue is waiting to be heard in court. So I can't talk a lot about the specific details, but I will bring out the general concerns and considerations and try to make it relevant. Okay, I mean, these things that we're going to talk about could really happen to anybody. So by way of background, so you understand what we're about to talk about. Where I live, these are single-family, attached 2-story homes in Middle Village, as I mentioned before. The zoning there is R4B. If you're not familiar with the zoning regulation, R4B is a low-rise house district that's limited to 1- and 2-family homes. And the 2 defining characteristics of R4B is that there's a height restriction of 24 feet and that the floor area ratio is limited to 0.9. That means essentially that the square footage inside your home cannot be more than 9/10 of the lot size. So that combination of restrictions typically produces a 2-story flat-roofed row house, and that's exactly where I live. So in this example, the applicant filed plans for renovating their property that included a 2-story rear horizontal extension. And in addition, they were building a rooftop terrace so they can go up on the roof and, for a recreational area. And that rooftop terrace also required a bulkhead in order to provide access. So getting to the second parts here. So the plans did include a stairway bulkhead that provided access to this rooftop terrace. The bulkhead construction involves the use of the party wall. We're going to talk about that. And since the bulkhead obstructs the chimney of the adjoining property, it involves construction to the adjoining property's chimney, specifically to raise it to a height 3 feet above the bulkhead. That would be, in this case, a total of 13 feet. In addition, of course, the contractors would require access to the adjacent property in order to complete the renovations on both properties, and that's the background. So what are the issues that we can examine? The first and the most basic, because this applies to just about any construction project that you may encounter, is access to the adjacent property. Okay, so in this situation, the applicant's agents do require access to the adjoining property in order to complete their renovations. That's fairly common. That's nothing unexpected. So the first thing I'll point out here is that it's absolutely clear the adjoining property owner cannot unreasonably refuse access. Okay, that's just commonly accepted, and that would be whether it's a construction project, whether your neighbor requires access to do upgrades or maintenance. They have to point their house, or they have to do something else. That's reasonable, and everybody can understand that. At the same time, the the adjoining property owner does have some rights as well. The person doing the construction doesn't have the right to just come on your property simply because they got approved plans and permits. There are certain requirements and certain rights that the adjoining property owner has. And in some cases, it's a trivial matter. They got to put up a scaffold for a couple of days and that's it, and it's not a big deal. But in other cases, I think the adjoining property owner should be very much aware of what could potentially happen and know what they can do to protect themselves. So first of all, the adjoining property owner does have the right to request what they call a license agreement. That would stipulate the conditions under which the contractors would be permitted to access your property. An access agreement or a license agreement could include any number of things, including you may specify the days and the hours in which they can work. You can specify where they can come onto your property, where they can't, and for what specific purpose. What are they allowed to do there? Are they just the workers going to be there? Are they bringing equipment there, or what have you? And also, most people aren't aware of this. If you're the adjoining property owner, you are required. You are entitled to compensation for allowing them on your property. Okay, most people don't know this. All right, so in addition to all that, it's important that you should get professional licenses, insurance certificates from the contractors, and make sure that you are a named insured on any insurance certificate so that you are protected. Okay, all of these are things that you can reasonably request as a condition of access. And I would add that I think it's a good idea to have them post a bond or put money in escrow before they come on your property in case that they do damage, that you know that there's money to cover it. Okay, so that's the first issue. And the second that pertains to this particular case has to do with alterations to the party wall. So here, their construction requires alteration to the party wall specifically to accommodate the rooftop bulkhead. Okay? And it's important to understand this one thing, that a party wall, it's the common wall between two houses, is in its entirety owned by both owners. It's not half owned by one and half owned by another. It's not the case that one owner can do something to their half of the party wall without consideration to the other owner, because it is just one wall. Whatever they do to the wall, you jointly own the entire wall. It's not divided by the property line, because you own the wall on either side of the property line in this case. So that's very important. There doesn't seem to be a lot governing the use of party walls in the DOB code. And believe me, we looked and we researched and we asked around. And it seems that the one thing that everybody refers to is this Department of Building memo dated February 19th, 1991. And it's funny, everybody knows about this memo. And it's like the only thing that I've found so far that really addresses the issue of use of the party wall in construction. So, to quote that memo, either owner of a party wall may increase the height of the party wall, provided that the wall is sufficiently strong to bear the additional weight, and provided it can be done without injuring the adjacent premises. Okay? The addition to the party wall must so be constructed so that it may be used by both owners. So, and then if the above mentioned criteria are met, then the adjoining property owner's authorization is not necessary. Okay, so this is what the Department of Buildings is telling people, that yeah, you can go ahead and do this as long as you follow all these rules and regulations. You don't have to get the permission of the other property owner. Now that may be true, from the building department perspective, but as we already looked at, there are obviously more practical considerations, like if they're going to work on the party wall, obviously they need access to your property, so they're going to need to talk to you about that. So it's not quite as simple as the memo makes it seem. In this particular case, the bulkhead that was being constructed was being built in a manner, it was just a frame structure. In fact, it wasn't being built out of masonry, as the party wall is, such that it just rested upon their half of the party wall. Okay, and so they made sure that it's not going over the property line, but nevertheless, as I mentioned before, the entire party wall is owned by both people. So even though they're resting the bulkhead frame on only half the party wall, that's not enough. They are, and just because they're not over the property line is not enough. They are, they have to comply with the requirements of the memo. And although it did, as I said, although it did not cross the property line, it was problematic because, well, first of all, damage was being done to the party wall. They removed the parapet caps to cover the party wall, and they did other damage to the top of the party wall in order to accommodate the bulkhead. This resulted later in water damage, okay, to the inside of the adjoining neighbor's property, okay, and it was significant damage. So that was certainly one problem. And the other problem is that by putting the bulkhead on the party wall, you're impinging it. It prevents the other owner from doing an alteration in the future that would require use of the party wall. So for that reason, it's, you know, so that's simply just not right. Okay, and so it's important to understand these things if you're ever in a situation where the party wall is being altered. Okay, so the third issue in play here is maybe a little less common but very, very important. So it's not only that they require access to the adjoining property, it's not only that they're constructing on the party wall, but now the adjacent owner's property itself needs to be altered as an integral part of the overall plan. Okay? So in this case, the construction of the rooftop bulkhead is next to the adjacent owner's chimney. And this would require, as I mentioned before, the chimney to be raised to a height 3 feet above the top of the bulkhead. Okay, so so this is a, you know, that's a pretty significant alteration, right? So there is building code that, that covers this. And to take a look, per section 27860, whenever a building is increased in height, the owner of the altered building shall have the responsibility of altering nearby chimneys to make them conform with requirements of section 27859. And that's where the 3 feet above the top of the bulkhead comes from. So the code goes on to say that written notification is required. You do have to notify the owner of the adjacent property that this is taking place. And you have to request their consent. And you have to provide them with plans showing the manner in which the alterations are to be made. Okay? In this particular case, none of that was done. Okay? The bulkhead was constructed, the party wall was impinged, and in fact, because these houses are adjoining houses, the chimneys are together. So it's like a double chimney, and in fact, in order to accommodate the bulkhead, half the chimney was literally cut away, and the other half was left, and then the bulkhead was placed directly abutting the chimney. So that immediately created a safety hazard because now the chimney is obstructed, okay? And this was all done again without prior notification, and this is not in accordance with, you know, clearly not in accordance with the building code. So here's the other interesting point of this section of the building code in 27860. It says, if the adjacent owner refuses consent or does not provide consent within 45 days of written notice, the owner of the altered building is released from responsibility for any equipment malfunction or safety issue that may arise as a result of the chimney not being raised. Okay? In addition, the owner of the adjacent property would now find themselves in a position where their home is no longer in compliance with code. All right, so again, it's kind of interesting that the language says you need to request consent, yet the consent is forced. Because if you don't give consent, well, they can do it anyway, and you're kind of stuck. So I just thought that's you know, an interesting aspect of the code here. So that having been said, the owner of the altered building does have the following obligations. They need to schedule the work so as to create a minimum of disturbance to the occupants of the affected building. That's also in accordance with a normal access or license agreement, as we talked about earlier. They need to provide, this is an interesting one, they need to provide such essential services that are normally supplied by the equipment while it is out of service. So in most cases, that would mean heat and hot water. So it just makes me wonder how someone should be expected to provide the adjacent owner with heat and hot water while they're constructing their chimney. So I'm not really sure how that aspect of the code is supposed to be fulfilled, but nevertheless, it's there. And when they go to construct this chimney, I'd be interested to see how they're going to provide me with hot water. Is it going to be in buckets or whatever? I don't know. But it's just another, it's a curious aspect of the code where, again, I think the code is written in so many cases where it doesn't take into account the practical considerations of how you're actually supposed to do this stuff, right? So again, continuing, where necessary, support the extended chimney from the other building. Okay, here's an interesting one. Make such alterations of the same material as the original chimney so as to maintain the same quality and appearance. Okay, so in this case, the chimney is made of brick, right? And in fact, the original plans were to raise the chimney using metal flue. So it would kind of look like a factory with a smokestack 13 feet in the air, pretty hideous. So that, again, was not in accordance with what's required of the building code. And going further, all work shall be done in such a fashion as to maintain the architectural aesthetics of the existing building. That's another one that I wonder about. And I just ask the question here below, how can a 13-foot chimney sitting on top of a 24-foot home be considered to maintain the architectural aesthetics? In my opinion, it can't. I think there are also safety considerations as well. And so what I have on the next slide is kind of a schematic to give you an idea of what all this looks like. I don't have photos or anything, but this is absolutely to scale. This is a depiction of these brick single-family, two-story row houses with flat roofs, okay, to scale, 24 feet in height. These buildings also are 18 feet wide. You see the normal height of the chimney at 3 feet, okay, and how that looks on the buildings. And this is what's being done in the proposed construction. So here's the bulkhead, and the bulkhead is drawn to scale. So I mean that's pretty darn big, and this is just a wall going around the rooftop terrace. And here's the 13-foot chimney. This is the chimney so the chimney that looks like this is going to have to look like this now in order to be in compliance with the code. And according to the buildings department, that's not only is that okay for them to do, but if the adjacent owner doesn't provide their consent, they can go ahead and do it anyway. It's kind of to me it's kind of disturbing that a situation like that can exist. While we're on this slide, because I'm going to go ahead, just take a mental note of what that bulkhead looks like and the width and the size of the bulkhead. When you think about it's only providing access to the roof and nothing more, but apparently it is doing something more. So let's talk about that, rooftop construction and what they call permitted obstructions. So in this case, the stairway bulkhead is being constructed on the roof to provide access to the terrace. So again, but R4B zoning limits the height to 24 feet, right? So how can they do that? Well, they can do it because there are exceptions. The exceptions are called in the code permitted obstructions. And the permitted obstructions include the obvious things that everyone would say make sense, like chimneys, like antennas, like vent pipes, and those kind of things that you would normally see on a roof. Maybe people have satellite dishes on their roofs and things like that. None of that would be considered an obstruction. But another permitted obstruction is a bulkhead that provides access to the roof via stairway. So that is considered a permitted obstruction, but only if the total square footage is limited to no more than 60 feet in area. Okay, and that makes sense because if you think about the width of a stairway, and 3 feet, 4 feet at the most, and the length, a typical stairway would be about 60 square feet, and that's why the limit is there. The proposed bulkhead in this case, as you saw from the diagram before, looks a lot bigger, and in fact, it's double the size. It's 15 by 8 feet, 120 square feet. That's the size of my bedroom. Okay, so this is kind of big. It's like they're trying to build a room up there. That's obviously not in accordance with code. In this case, at one point along the way, the buildings department did audit the plans, and they found that they were defective, and they issued a notice to revoke. Okay, yet strangely enough, when at the audit plan exam meeting, when the architect went down, the audit findings were cleared. even though there were no modifications made to the approved plans. So, so how did that occur? All right. Right? I'm not going to say any more about how it occurred, but and so again, it's very, very concerning. So, I'm not going to talk about more detail of that, as I mentioned, because this is pending a court case. So I won't go into more detail, but I'm going to leave it at that and let you think about it. But that raises the next question: what do you do when you're confronted with the situation when where there are approved plans that you suspect or possibly even know for a fact are not compliant with code? What can you really do about it? Well, you can do the obvious things. You can file complaints with the buildings department, and they do respond sometimes. Sometimes they'll, we've done that, and we've had inspectors come, and we've had inspectors dismiss the complaint, and most of the times they dismiss it with the comment that plans were, construction is according to plan, and plans were approved, and permits were issued. So as long as the plans are approved, that's okay. So it's very hard to, to move forward with these things. The one thing I would tell you, just don't let anybody tell you that there's nothing you can do. If you're talking to a government official, you're talking to someone from the buildings department, you're talking to an attorney or anybody else, don't let them tell you that there's nothing you can do if the neighbor has approved plans and permits, because that's not true. Plan examiners, auditors, inspectors, they make mistakes all the time, okay? These plans were approved, obviously, when they were defective, and they're still approved. So we looked around. We tried to, early on, we did our best. We went to the buildings department ourselves. We filed complaints, didn't get addressed. We went to our local representatives' offices. They didn't really help other than to say, file a complaint. One office gave us the name of an attorney who we contacted, and that attorney said, oh, I'm not touching this case with a 10-foot pole. So it really wasn't much help. We, through a lot of diligence and a lot of hard work, we eventually found an attorney who specializes in land use and zoning, who is willing to take the case and who's helping us now. And again, so this will be heard in the courts at some point in the future. But, and then, finally, well, not finally, I have a couple more slides to go. There are the aesthetics and safety considerations. This is, again, speaking from the perspective of a homeowner who's lived in the neighborhood for more than, or lived in the neighborhood all my life and owns a home for more than 20 years. And, zoning regulations are there for a reason, to maintain the consistency and the appearance of a neighborhood and not to have these outrageous types of construction going on. So, again, so these are single-family attached homes. They're not apartment buildings. They're not high-rises, or they're not even two-family or three-family homes. I think, having a rooftop terrace is not in accordance with the aesthetics of the neighborhood. It's clearly visible from the street. A 13-foot chimney is more than 50% of the height of the house. That is not going to maintain the aesthetics, and if one person does it, you can be sure other people are going to do it. And the next thing you know, you're going to see the neighborhood littered with these rooftop terraces and bulkheads and 13-foot chimneys and the rest of it. So, that's something that I'd like to see addressed at some point with city planning, and to see if, the loopholes in the zoning can be tightened up, because I really think that it does detract from the look of the neighborhood. The safety considerations that, I was thinking about personally. Someone who has a rooftop terrace, row houses, flat roofs, provides easy access to the rooftops of all the houses along that strip. That's it. What about patio furniture and other objects could just blow off the roof in a high wind? We've had plenty of those. We've had hurricanes. We've had tornadoes come through here. Someone has a rooftop terrace with their patio. I can imagine that flying off the roof, hitting somebody. It's a hazard. And I'm concerned over the structural integrity of a home that I own, which is 70 years old, and with a chimney that's now been damaged, and how that's going to hold a 13-foot extension. It's been cut in half in terms of width, and now it's going to be raised all this height. So there's so there's those concerns. And then finally, this is the last slide, and I'll open it for questions. The approved plans and the challenge process. I don't know how many are familiar with the challenge process, but basically, to put it simply, whenever plans are provisionally approved by the Buildings Department, a 30-day public challenge period will commence. Okay, it appears on the property profile on the Department of Buildings website, and it says, challenge period. And during that challenge period, you can go ahead and file a challenge or an objection if you think something that's being done is not in accordance with the zoning or objectionable in some other way. There's a couple of problems with that. First, of course, how do you know that something has been posted as a challenge? You have no way of knowing unless you're like checking the Department of Buildings website and all of your neighbors' property profiles like every few weeks to see if something's there. How would you ever know? And in fact, that's what always happens. These challenge periods always pass. Nobody ever knows they were ever there. And even if you did know about it, what's the basis of your challenge? In order to challenge something, you need to see the plans. And the kind of plans that they post on the Department of Buildings website, just the zoning diagrams, are so minimal that you really can't get an appreciation for the construction that's being proposed by just looking at that. So I don't even know how you would get the basis of a challenge. Additionally, there's only one challenge period. It doesn't matter how many amendments the plans undergo or anything else. So, and what happens there is that savvy builders do take advantage of this. They will submit plans for something innocuous at first, let the challenge period pass, and then all of a sudden submit an amendment for something that looks nothing like what they originally submitted, but there's still no new challenge period. So the whole challenge period process is really flawed. And just to wrap it up, what I think is really unbelievable and must be changed by the DOB is it's the faulty process that allows this whole situation to occur. In this case, you think about it, there's a person who got plans approved for not only plans approved and permits issued, not only for doing construction and alterations to their own house, but they got approval to alter another house. And that other person is never notified. In advance, never notified. But they get permits issued in order to alter someone else's property. To me, that's just outrageous, but it happens. And there's no requirement to notify the owner of an adjacent property that you plan to alter their property. To me, it's just mind-boggling. But anyway, that's my presentation.